and welcome to Terms and Conditions, the podcast where we demystify labor and employment law by discussing the issues in a grounded and accessible way. My name is Letitia Silas,
And I am Samuel Rose.
and we are attorneys with the Con Maciel Carey Law Firm.
We represent employers across the country in all things labor and employment.
Why don't we dive into just a little bit of our background and who we are?
I'm Samuel Rose. I am an attorney out in California in the Los Angeles area. I've been an attorney since about 2018. Had a range of practice areas from criminal law to now labor and employment, with a couple stops in between. And have really enjoyed learning labor and employment law and learning about the NLRB and all these issues that we will eventually discuss on this podcast.
Fabulous. And I'm a traditional labor attorney. I'm a traditional labor girl, right? And I have worked in both the labor and employment space, but really focusing on that traditional labor and employee relations, labor management relations. I started my career with the National Labor Relations Board. Well, actually, that would be my legal career. I started my professional career with the Office of Federal Contract Compliance Programs, OFCCP, with the federal government, and then went to law school and then became an attorney, starting with the National Labor Relations Board. And from there, I went into private practice, working at a major law firm, and then went in-house as in-house counsel and director of labor relations, and then went back to a law firm, and then took on an executive role in a large system in California. And now I am back with a law firm. So I have seen it all and done it all in the labor and employee relations space, and I'm glad to be here.
That sounds great. I think it'll be a lot of interesting perspectives that we can both bring to these issues, hopefully.
Excellent. So, Sam, why is this podcast important to you?
Well, I think it's important for a couple of reasons. The main one being the law is extremely complicated, right? And most of our clients are not lawyers. They don't have law school backgrounds or legal backgrounds. And so our main job oftentimes is to explain very complicated legal concepts to people so that they can apply it to their jobs or their companies or their employers. And I think it's really important for the public in general to understand labor law. Almost everyone in the country works, and so it really touches everybody's life in one way or another.
Absolutely. Everybody in the country works, and I mean, frankly, everybody in the world works, right? Generally speaking, we all have to work, and work is central to our lives. And that's why doing this podcast is really important to me. You're right. The law is very complicated, and we need for companies and clients to know the law. But the way that people get to know the law is when they can relate to the law. And so this podcast is important to me because we will be getting honest about the law in a grounded and accessible fashion so that people can relate, people understand, and they actually walk away with information and tools that are useful.
Totally. Can't agree more.
All right, so why don't we dive into our discussion for today, which is employers monitoring employees' return to work or monitoring through electronic means or artificial intelligence employees' movements and activities at work.
Yeah, I think this is a really interesting topic that has obviously taken off over in the last couple of years with the pandemic and people being forced to work from home and employers having to adapt to determining and measuring productivity in a new and different way that most employers probably weren't equipped to deal with at the time and had to ramp up very quickly. So I think it's a relevant topic. It's been a relevant topic and it will continue to be as companies decide whether to, and we'll discuss this, I'm sure, shortly, return to work or maintain a work from home element to their policies.
Absolutely, you're right. It's so funny, Sam, because prior to the COVID-19 pandemic, I mean, the ability to monitor things, video conferencing, all of that stuff existed. It's just that no one, at least in my circle, in my space, was paying attention to it. And when we were all forced to work remotely and to shelter in place, it was aha, a light bulb went off, and we really can communicate and get the work done in a remote environment. But it also turned the light bulb on in other respects, right? And then even during this period, we've come out, well, not, I don't think that it's come out, but we are talking about artificial intelligence more and more now, even with this more virtual setting. So I think that a lot of employers are trying to adjust to that, and employees are trying to adjust to that. And obviously, in many cases, labor unions who represent employees are trying to adjust to that. So, what are your thoughts? I think I read something recently um, that said that one employer had sent out a memo to about 25,000 employees, letting them know that it's time to come back to work. Time to report back to work, and that the employer would be monitoring compliance with that directive. Are you familiar with that article?
I think I did see that one. Yes. It was interesting. It seemed like it was centralized to their UK team, which I thought was interesting. It wasn't applicable to the US team. And I think we might get into some reasons why that might be. Um, but it was an interesting topic, and it seemed like they were kind of lumping in location, like the employee's location, with other productivity measures like billable hours or other metrics that the employer uses to assess employee productivity. And I thought it was interesting that it was just kind of thrown in as another example of how they're going to measure your performance.
Absolutely. I mean, it's similar to what I've heard of and seen in the past of employers monitoring productivity through keystrokes and being able to tell whether or not an employee is working based on their keystroke entries. And I believe a very major employer recently, I believe, took some action, an employment action. With an employee with respect to the keystrokes, and making a disciplinary decision based on keystroke data.
Interesting. I didn't see that one.
Yeah, very interesting. So, what are your thoughts though when it comes to this monitoring employees, and what are some of the things that, as employer representatives and employers out there who are well intentioned, we want to do the right thing, but what are some things we should be thinking about in this space?
So I think the first thing is that an employer obviously has an obligation and a right, to ensure that the people it's paying salaries and wages are doing the jobs that they're hired to do and complying with their job requirements and job duties. But as we know as attorneys, the way in which you do that is very important, right? And there are lawful ways to do it and there are unlawful ways to do it. And I think that the reason why this practice has become such an interesting topic is because it kind of is a gray area. On the one hand, you think, yes, you have a right to determine whether your employees are being productive and are in the office and are using spaces that we pay a lot of money to maintain, right? But on the other hand, and I think the counter argument and counter authority is people's privacy, and what balance of privacy you have when you're at work or at home working to your employer, and what the employer has to uh, consider of your privacy in those scenarios.
And whether or not there's even a right to privacy
Right.
in private practice, right? In a private employer setting, is there a right to privacy? We know that in the public employer setting, there are certain rights attached with respect to privacy and speech. But in the private employer context, that could look differently. And so it's really important that employers know what their expectations are and what the law is federally and in their area, their state or their locale with respect to this question. Also, whatever policies that they've put in their handbook or elsewhere, they should also be familiar with those policies so that they can make sure that the policies are not only legally compliant, but where they are legally compliant, we actually are following our own policies.
Right, exactly. I think oftentimes I see handbooks with policies in there, and you ask the HR representative or your contact at the client and say, "Are we enforcing this policy at all?" And they're like, "Oh, I didn't even know that that policy existed." And that's a really important thing, right? You don't want to have policies on the books that are either pointless or not enforced, because that just gets you into all sorts of trouble potentially later on. And privacy, working from home, employee tracking, that kind of stuff is definitely one of those areas.
Absolutely, absolutely. And really notifying employees and knowing like what's on camera, right? Or what's on keystroke monitoring or what's on, what is being monitored. What specific part of my job is being monitored. So in the employer's case who is mandating return to work, well, what's being monitored? Is it when someone walks in the door and they their time card? Is it sensors in the building? Like, what exactly is going to be the means by which you track this information? And how can we also ensure that the information date or the data collected is actually accurate and reliable, such that we can make personnel decisions based on it?
Exactly. And safe. I think keeping that information safe from, we see, I feel like almost weekly now we hear about a data breach at certain employers. And that's all really sensitive information of where people are at what particular time. I think one of the first issues that not issues, but one of the first topics I thought of when I read that article was, and I think it goes to your point about whether you have a right of privacy. If this is information that is being tracked on a company, let's say a company swipe card, right? Like you go to work, you enter the office building and you swipe your key card to get through the gates and go up to the office. And then when you leave, it swipes your key card and that tells you when you leave, right? There's nothing there that's your personal. They're not tracking when you get home, when you leave your house, when you're in your car. That doesn't seem like a right to privacy because it's all within the context of your employment. And I'm curious whether you think that that's whether employers should be mindful of limiting the data collected to that type of thing. Keystrokes on a work computer versus keystrokes on a person who uses their personal computer for their work activities. What do you think about how those interact?
Listen, well, I think if you're doing work, use the work equipment. If you are typing memos, you should be doing it on the work computer and storing it on the work computer, which likely has a lot of security built into it, virus protection, all sorts of firewalls, things that you need. And you should not be storing employer information on your personal computer. In terms of phones, right? I say that, you should be using a company phone, right? Because for many reasons, not only this, but suppose you are an HR official and you make personnel decisions and your phone is subpoenaed because you were sending emails and text messages from your phone concerning the decision or the incident leading up to a personnel decision. Making your phone, your personal phone, vulnerable in that way, I don't advise. I think you should be using a company phone, and company business is done on the company phone, so that if one day you are asked to submit your phone records, you can do so confidently, knowing that your personal life, the details of your personal life, your doctor's appointments, your conversation with your mom, right? Conversation with your children, right? Or your spouse, those things won't be potentially disclosed to outside third parties. You keep it in your company phone. Keep company business in the company phone.
Totally. And I think that extends to, you brought up HR professionals, and I think it extends down to hourly employees as well. There's oftentimes an employment lawsuit results in witnesses being hourly employees, right? And I've had cases where hourly employees' personal cell phones were subpoenaed because there was information on there related to the case, and it made a really awkward interaction between the employer and the employee because there was nothing the employer could do to prevent this subpoena from being executed. And it's I think it's especially important for that employer and employee relationship and morale, right? To know that you can trust your employer and your employer can trust you. And I think that goes to what you're saying about issuing company cell phones where the employee doesn't have to worry about the employer or someone else breaking through that privacy barrier into their own personal life.
Absolutely. And you said something really key, Sam. You talked about morale and trust. And so when we are thinking about policies that involve monitoring people, we should also be thinking about the impact that that could have on workplace morale overall and the relationship of trust that we have with the employees, right? So we want our employees to believe that they can trust us, that they can come to us and discuss their issues with us, and that we will be responsive and not treat them. Well, let me put it a different way. We will treat them in a respectful manner and not as though they have to be policed all of the time. Well, because if that happens, then employees feel like maybe they need to go get some sort of outside assistance to help control the policing and to help be a mouthpiece for them and to help facilitate that relationship that they should be having with their employers.
Absolutely. Yeah, I think that's one of the main, I'm not going to say the main issues, but one of the issues we definitely confront with our clients very often is the is the pro of this policy outweighed by whatever negative ramifications it's going to have on your employees' perception of you or of the company or of their desire to work for the company? Does that balance weigh in favor of implementing this policy? And if it does, and oftentimes it might, then go ahead and implement it. But you want to consider it because that is a business reason, right? If people leave, if you lose morale and you lose employees, it's an expensive and time consuming process to go and replace those employees. And oftentimes it's not in the employer's interest to do it.
Absolutely. So let's go into some of the other issues here. We talked about privacy. Another thing that came to mind for me is actually storing this information. Where is the information going to be stored? If we're talking about a card scan, or if we're talking about scanning the eye or fingerprint scans I've seen, where's this information going to be stored responsibly and safely? And how is it going to be disposed of when it is no longer needed? And should there be a sunset on this, on storing this data?
Yeah, I think that's a very interesting and important topic if you're going to go down this route. It's interesting because I oftentimes clients will ask questions like that, right? And I think we oftentimes we're not experts in everything. I'm not an IT expert. I'm not a technology expert. I think it's important that you have a whole team of people, right? Like im- attorneys can help advise on the legal obligations or legal risks, but you should also have IT people or technology people who can explain to you and help you figure out how to store this information safely, where to keep it. Do you want to keep it on paper? Do you want to keep it digitally? And then the other issue is, like you mentioned, how long you want to keep it for. And I think oftentimes we'll look at potential causes of action that can arise from this type of conduct and say, you want to keep it for probably a year or two after the potential statute of limitations for someone to bring the claim, right? Just so that if an employee does bring it a lawsuit of any kind, potentially related to this conduct, that you have the documentation and the evidence to defend the lawsuit, right? Or to show the employee that, and it's not necessarily in an adversarial way, but just look, like here's the information. It wasn't compromised. We complied with the law, and we understand that you might have been surprised or concerned about this information, but we've always maintained your privacy and your interest by maintaining this data.
Absolutely. And also, who will have access to the information? Putting guardrails around who can access fingerprint data. right? Because that's very sensitive and we don't want that falling into the wrong hands. And yes, sometimes, whether we like it or not, sometimes the wrong hands got hired and they work in the business, and we're trying to, ensure that folks that we hire are obviously trustworthy, but we have to guard against the potential that this information could land in the wrong hands. So we need to put guardrails around who should be able to access this type of data.
Absolutely. Yeah. And I think as generally the topic will, or the answer will be as few people as possible, right? Only the people that need it, and as limiting the amount of people that have access to ensure that there's no accidental access or inadvertent dissemination of the information, those kind of risks, alleviating those as much as possible.
Absolutely. Another thing that came to mind for me is the use of the information. How are we going to use the information? So, we talked about the employer who intends to use data collected to ensure or track compliance with the return to work mandate. But will discipline result if people don't comply with the mandate? Will we be collecting eye scans and fingerprint for time keeping purposes and then using that information to issue discipline? Will we be using it for other purposes, such as maybe selecting benefits plans, right? Will we be using that information for the purposes of marketing, right? Because in collecting some information and how you choose to collect it, you are learning the pattern of an individual, their unique pattern, whether it's in a fingerprint, whether it's in how they go to work, whatever it is, you are learning something that is potentially unique to that individual. And how will that information be utilized?
Absolutely. And, you know, are you, that's why it's so important to have these policies in your handbook and make sure that they are specific. And I mean, specific is an important term for the NLRB, and I think we'll get to that topic very shortly. But specific for that purpose, but also specific just for your own purpose, so that you don't get into a situation as the employer where you're now beyond the bounds of what you've told the employee the information will be used for, right? If we're saying we're going to track this information so that we can see that you're in the office 3 days a week, but eventually someone decides to leave work early because they have a doctor's appointment, didn't ask for permission, is the employer then able to use that card scan to show that the person was at work, right? They did show up to work for their scheduled day of being there, but they left early, and now we have a wage issue. And is that within the bounds of what you're able to use that information for, according to the policy, according to your handbook, according to the law?
Absolutely. And a wage issue, potential disciplinary issue, all of those things. And you're right, according to the law. So, why don't we dive in a little bit to what we saw come out of the General Counsel's office for the NLRB in 2022? There's a memo that was issued, Memorandum GC 2302. Subject line is electronic monitoring and algorithmic management of employees interfering with the exercise of Section 7 rights. Ooh, that's a mouthful. Can you can
Uh,
you demystify that, Sam?
that was a mouthful. So the NLRB obviously is the, maybe not obviously, I shouldn't say that, but it is the board. It is the board that determines violations of the National Labor Relations Act, the NLRA. And the NLRA is predominantly focused on an employee's ability to organize and to stand up for their rights as employees against employers. I think what's interesting about this one is, and really any, let's start out from a very broad perspective. The NLRB will often, and the General Counsel will often reference these Section 7 rights. And I think as a young attorney, still learning, I oftentimes hear, well, this is an important surveillance and monitoring issue for, you have to ensure that it doesn't interfere with employees' rights. And I think maybe an important place to start, Letitia, from your experience, and you've had a ton of union experience, general labor experience. What are those rights that you can't interfere in? Because it's a very broad
Oh.
It's very broad language. Is it your right to go to work, your right to work, your right to organize? What are these rights that are implicated by the NLRA?
All right. Are you ready? It's
I'm
legalese. So
ready.
we'll have to demystify this. So, the right to form, join, or assist a labor organization, generally, and to engage in protected concerted activity for mutual aid and protection. Now, that protected concerted activity has to concern terms and conditions of employment, and it has to, as I stated, be for mutual aid and protection. So, what that means is engaging in certain activities to improve the lot as employees, right? So we are engaging in this type of activity, but suppose I'm an employee or you and I are employees. We are engaging in this type of activity because we're trying to improve our circumstances with respect to work, our terms and conditions of work, where we work, for whom we work, with whom we work, the conditions under which we work, right? The who, what, when, where, how of work we want to improve upon or have a say in. And so the law, the NLRA, the National Labor Relations Act, provides space and legal protections for statutory employees to be able to engage in that activity.
So I think before we get to specifically the monitoring and technology information, um, if I my question from a layperson perspective is, if a policy like technology has a motive or purpose that is not interfering with employee rights under the NLRA, but it has the accidental implication of interfering with their rights, is that a legal, lawful practice?
Well, certainly the GC is making that case in the memo, I believe, and many aspects of the National Labor Relations Act and potential violations don't have a motive requirement, meaning you had to have acted with some sort of illegal motive. It's just the fact that you did it, and employees could reasonably construe your actions as interfering with their rights, right? And so I think I'm saying that broadly enough. And but essentially, if I set up a keystroke monitoring system, and suppose I am sending messages to my coworkers when I'm on break, because I understand that I can engage in certain solicitations during non working time, even if in a work area, but I'm using my computer. Now that raises a whole other legal complication or legal question here. And so for the lawyers that are listening, yes, I know that Caesar's Palace is out there, but just flow with me here. But suppose an employee is doing that. Suppose we're still under the old standard of purple communications, and I'm using my computer during non-working time, and I'm sending messages saying, "Hey, you know, I don't like the fact that our breaks are only 15 minutes long. What are we supposed to do with a 15-minute break?" And other employees on that 15-minute break are also starting to chime in, right? And just suppose that the employer says, we have 5 people or 2 people or 3 people who are, their keystrokes are moving along during the break period. Maybe we need to go look in to that. And then they find out that employees were doing this, and maybe they were talking about their breaks. And then suppose the employer, let's just play it out, takes some sort of disciplinary action or reprimands the employees for engaging in that activity. I see that as being a one type of an example of how that monitoring could potentially interfere with employees' rights to engage in certain activity. Now, again, we know that the law with respect to employees' use of employers' equipment and IT systems has changed now, and employers can restrict that use, but just keeping in mind how that monitoring could play out in the context of interfering with employee rights.
And I think that's a perfect example of what we were talking about earlier, which is the conflation of protecting employee rights under the NLRA and other obligations that an employer has, right? in California, for example, a break has to be with no work, no assigned work or duties whatsoever related to the job. Well, if you see your work computer keystrokes, an employer has to confirm that that employee isn't working on their break, right? They have an obligation to make sure that that employee is not working. And so while they've done this for a legitimate purpose, like you've just explained, there is this other aspect where they are now potentially interfering with employee rights. And that delicate line for employers is one of the hardest things to be able to overcome.
Absolutely. I mean, you might even have instances, let's just say that there's monitoring, meaning motion sensors, and maybe a bunch of employees are getting together to go into a non work area to discuss working conditions. Maybe it's what did you get on your performance appraisal? Well, I got this, and well, you got that, and that's not fair, right? Discussing that. Maybe it's, talking about joining a union. Whatever it is, they're coming together to talk about terms and conditions of employment or talking about forming or joining or assisting a labor organization. And they're doing it, and you can monitor their movements. And if they know that you can do that, they may be discouraged from getting together, right, and doing that. So that's another example of potential interference. If employees know that it exists, and because it exists, then they are discouraged from talking about or working together concerning their working conditions or engaging in Section 7 activity.
Absolutely. I think that raises another issue, which, you know, a lot of listeners might come from different working environments, different professions, different industries. And I'm wondering if people listening might think, well, I'm an accountant. Like there's no union. We don't have a union. We're not going to form a union. It's not even on our radar. Does the accounting firm have different considerations from a manufacturing firm, for example, or a production firm or a production company, sort of? How do you advise different industries on whether the Section 7 rights apply? Do they apply to all employees? Do they apply to certain employees?
Well, in private practice, they apply to all employers, generally speaking, right? There's a jurisdictional threshold, which is really low, and I'm not going to complicate things by going into that. But at 10,000 feet, right? Generally, all employers are covered. There are some very few exceptions, and statutory employees with very few. I mean, first of all, to be a statutory employee, that means you're not an independent contractor, right? And there are certain other types of exclusions, such as if you are a child of the owner of the company, right? Children of the who in a family business, they are not statutory employees, and so there are specific definitions. But let's just suppose, that those are not included. Generally, all employees. It doesn't matter that, oh, you have an accounting degree or you're a lawyer, right? You might be a supervisor. That's excluded. But again, I said statutory employees. So you have to know what a supervisor is under the National Labor Relations Act. Agents of the employer are not included. And so you would have to know those definitions. And so you should be consulting with legal counsel to know that. But generally speaking, if you don't fall into one of those buckets, employees, if you're an employee, you're covered, right? So even if you have 5 degrees, and one of them is an MD, maybe, right? Or a JD or a PhD, you're still covered. So it doesn't, there is no exclusion because you are part of a learned profession, in other
I think
words, right? Even professionals are covered by the National Labor Relations Act.
I think that's an important thing to know, because I think oftentimes we think of unions as um, factory workers, delivery people, U.S. Postal Service, like those types of jobs. But that's not, the NLRA does govern unions, but it also governs a wide variety of employees. And I think from an employer perspective, right, oftentimes you might forget that the NLRA exists because you're not involved in union elections, you're not involved in collective bargaining. And so you don't immediately think about the NLRA as pertaining to your operations, but it very often does. And these types of return to work policies are often applied to office workers, right? Which might be covered by the NLRA and which might interfere with Section 7 rights.
And most of the time, it is covered by the NLRA, right? It's
Right.
not even like only some of the time. It's like 90% of the time, unless you are, there's some jurisdictional limitation that says that the NLRB does not have jurisdiction. And that involves an examination of, interstate commerce types of questions, not whether you're a hospital versus a factory, right? Not whether you're a CPA firm versus a what's a car dealership, right? That's not the analysis. The analysis is on interstate commerce questions. And so if you're an employer and you have employees, whether or not there's a union there, whether or not your employees are unionized, you are covered by federal labor law. And so you should be mindful of these things that Sam and I are talking about here, because everything that we've talked about here has generally been in what we just identified as the space of protected concerted activity concerning terms and conditions of employment for mutual aid and protection, right? That's a mouthful. But what that means is employees are acting together concerning their terms and conditions of employment. And there doesn't even have to be a union on site or even an interest in unionizing for that to happen. So as long as employees are, say, for example, getting together to talk about their wages, getting together to talk about the supervisor they don't like, right? That very well may be, and like is often, protected concerted activity.
Definitely. I'm curious what your obviously general observation, general experience. Um, how interested is the NLRB in, for example, I'm trying to figure out how to say this, monitoring and let's just say an accounting firm's return to work policy, the use of a monitoring system for an accounting firm. Is that on the NLRB's radar? Is that something that the general counsel is interested in? Or is the risk fairly low?
Well, based on the memo, actions like this are on the radar. And so, again, that memo is GC Memo 23-02. And you can find it on the NLRB's website. You just go under guidance and you go under GC Memoranda, and then you can find the memo there. It is pretty lengthy. It is 9 pages long, single spaced, with lots of footnotes, but it's good information. So I would say things like that, as well as other types of monitoring and the use of AI and technology, is definitely on the general counsel's radar. And so we should be, as employers, mindful of that as well. I mean, even before we were talking about AI and sort of this whole virtual space. I mean, just employers' use of surveillance cameras in their operations were on the NLRB's radar. And there are many, many cases about employers' use of surveillance cameras in the legal sense and in the unlawful sense, right? Where employers they ordinarily have security cameras, and they normally, under normal circumstances, surveil the workplace to ensure safety. Then you have cases where maybe an employer set up a camera all of a sudden because they believe employees are getting together in the back to talk about working conditions, right? Maybe in the stock room or in some location, maybe out in the alley where employees take their breaks. All of a sudden, there's cameras there, didn't have cameras there before, right? Or maybe suppose employees are engaged in a protest and the employer doesn't ordinarily surveil a certain part of the property, the perimeter, but all of a sudden this protest breaks out and you have the employer zooming in on these, parts around the property where it ordinarily doesn't monitor activity. Those are the cases where you're going to find a violation of the National Labor Relations Act. So the question of surveilling employees has always been within the realm of labor law, federal labor law. I just think that it is manifesting differently in this new era with the use of AI and more advanced technological means. And so we have to start applying different lenses to how we look at things.
Absolutely. I mean, the NLRA was passed in the 30s, and there's no way that it could have anticipated the GC or the NLRB having to confront issues like artificial intelligence or even surveillance cameras at one point, right? This was all new and groundbreaking technology at one point, and applying this new technology to an extremely old statute is sometimes very difficult. And so that's why following the NLRB's decisions on these types of issues is very important for employers to always be up to date on the latest trends and the latest positions of the NLRB.
Absolutely. And I think that something that we should demystify here is really the difference between employment law and labor law. So it's really important that you understand that what we're talking about arises under federal labor law. So if the only thing that you're doing is looking at EEO law, looking at the EEOC, maybe even looking at other federal agencies, and you have forgotten about the National Labor Relations Board and the National Labor Relations Act, that is a serious oversight. And so my thought is that if I'm an employer and I'm thinking about implementing a certain system of tracking or monitoring, and I want to be able to use the data in a certain way, I'm going to engage with competent labor counsel. Right. That means that if I have an attorney on board who's doing employment, I'm going to go to that attorney and say, do you know traditional labor? And if the answer is no, then I'm going to want to go get competent traditional labor, somebody who deals in the National Labor Relations Act day in and day out, so that they can advise me on the risks and the opportunities with respect to my plans.
Absolutely, that's a great distinction, Letitia. And a good thing to point out. I think we conflate labor, even the practice area is called labor and employment. We conflate it very often, and they're very much two different things, and both important but very different things.
Very different things, both important, right? I mean, both are, we need both, right?
Mhm.
And employees have the protections of both. So employers have an obligation and a duty to, it should know both. But totally different tracks in terms of complaints that can be filed, how those complaints are processed and even litigated, and the types of remedies that
Mhm.
are available, right? And what it could mean long term. Also, has a totally different, in many instances, impact. Like you might have a case where we're talking about protected concerted activity, employees engage in that, and then you get a complaint or you get a charge filed with the NLRB. Let's just play it out. Maybe it results in a complaint. Let's just play it out even more. The complaint has a merit finding, and then it goes to the board, and then there's an order, and then all of a sudden a union says, "Aha! They have issues over there. I'm going over there." Right? And now the employees are now union organizing, when the case started out as just employees engaging in other type of activity. And I don't know if we really see that as much in the labor, I'm sorry, in the employment context.
Absolutely, yeah. They're very different considerations, and it's almost that initial complaint that you just described is a relative employment issue that became a very big labor issue, right? And so if you had an employment counsel dealing with that case at the beginning, not thinking about the labor issues, well, you turned that into an extremely problematic labor uh, issue for that employer. And that's a great example of how the two areas are very different and both important.
Right, right. And so you have to have counsel who's able to advise you and who's able to defend you. I can't tell you the number of times I've seen, position statements or just types of arguments where, yeah, this doesn't sound like labor law. This is employment law that you're applying here. That doesn't really fly here. Like you have to cite labor law.
Mhm.
And no, generally just citing a bunch of circuit court cases is not going to help you when you are trying to defend a position before the National Labor Relations Board. But I think that's just, it could be helpful, but it is not the precedent that the board follows. So with that, Sam, I think we have really done this subject justice. And I think we have left the audience with some tools to think about and to consider. And do you have any just last thoughts?
No, I think it's just a very interesting issue, and I think employers should definitely stay on top of it, especially those considering implementing some of these policies. And looking forward to discussing the next relevant topic in this amount of depth again, Letitia.
Absolutely. So, everyone, again, you were listening to Terms and Conditions, the podcast where we demystify labor and employment law in a grounded and accessible way. I am Letitia Silas,
I'm Samuel Rose.
and we are attorneys with the Con Maciel Carey Law Firm.
Thanks for listening, everyone.
Thank you.